issues they agreed to. We are counting on the province to hang tight and fight this on environmental issues. And Don Avery was sued for saying those things. The impact on the community was considerable. I'll just read you a couple of quotes. This is from the sworn testimony that was provided for other members of the Big Bay Point community who felt too threatened and harassed to actually participate in the OMB hearing. This is a quote: "I feel threatened, harassed, and intimidated by Geranium's legal claims and fear exposure to lawsuits and costs associated with defending them. I do not write letters to the town, county, province, or local papers for fear of repercussions from the Big Bay Point developers, Kimvar Enterprises, and Mr. Ram. From fear of being implicated in a lawsuit myself, I would not write a letter or voice my personal opinions about the project in any way whatsoever." Jeff Howard is a resident of Big Bay Point. He's a 15-year-old field naturalist. He discovered Blanding's turtle, a threatened species, on the development site and reported the sightings to the MNR. Then the firm of Davies Howe came after Mr. Howard, and Mr. Howard ceased participating in the hearing. And I'll read to you from the letter. Mr. Howard advised that if we do not cooperate, his client, and I quote, "reserves the right to take, without further notice, whatever legal steps are necessary and appropriate." She believed this was a clear threat. Ms. Howard was so frightened of legal suits, she did not swear the affidavit and participated no further. As a result of our experience at Big Bay Point, the concerned residents of Hilldale fighting another geranium proposal in Simcoe County were quoted in the Toronto Star as saying, "Crow felt intimidated by the Hillsdale Land Corporation," that's Geranium, Mullings told the provincially appointed board which adjudicates land dispute. "Crow felt it had to soften its position to protect its residents from litigation." They withdrew their objection to the Hillsdale Corporation suit. And I have to ask, where was the Attorney General when the board's rules say that you are not to threaten or intimidate parties at the Ontario Municipal Board hearing? They accepted at face value. When the concerned residents of Hillsdale withdrew their opposition, they didn't question it. On April the 8th this year, the province of Ontario entered into minutes of settlement in the Bradford West Gwillimbury Newtown proposal. It was registered in the board's decision that the only opponent of the project had been served but had not been filed a cost claim against the group, even though the hearing hadn't proceeded, and that the only opponent to this Newtown proposal in South Simcoe County withdrew its opposition because of this threat. And the threat was issued by the firm of Davies Howe, Michael Melling, the same lawyers in our case. I know we only have another minute, but I have to go into the historical record here just a bit. I have had a terrible experience being the subject of developers and their intimidation and slap suits. In trying to defend a place called Moon Point, only one of 3 natural shoreline areas remaining around Lake Simcoe, we went to the Ontario Municipal Board. As a result of my critical comments of the Lake Simcoe Region Conservation Authority in the local newspaper, in the spring of 2006, the Conservation Authority launched a formal complaint to the Law Society of Upper Canada against me and sent a libel notice. It took several months to resolve and considerable resources of my then firm, Gilbert's LLP. Mr. John Ola from the Bay Street firm of Beard Winter was the solicitor for the Conservation Authority. The Law Society dismissed the complaint without taking any action. It was meritless. But there was no record of the decision to pursue this libel claim or this complaint against me in the Lake Simcoe Region Conservation Authority board minutes. When asked why this decision was made without a public process, the response from the LRCA was that Mr. Ola's services were donated pro bono, but that his fee, in fact, was paid by a, and I'm quoting now, developer on the lake. The Lake Simcoe Region Conservation Authority will not furnish an explanation for how a public agency could receive money from a third party to fund a claim against a public advocate. In the Milroy prosecution, one of the first times that the Government of Ontario was prosecuted successfully for not following the Environmental Assessment Act, there was a claim by a member of the Ontario Realty Corporation that I had deliberately misled the court. This was a false claim, and the ORC subsequently apologized. But it's interesting to note that Mr. Michael Miller, the lawyer in the Big Bay Point case, actually swore that affidavit making that outrageous accusation. In North Leslie, the firm of Davies Howe, Michael Melling, filed a motion of contempt against me and obtained a summons accusing me of lying to the Ontario Municipal Board. After 1 year with no response, the firm of Davies Howe apologized. In the Warden 16th hearing, where we fought to save a red side base bearing trout stream in the Rouge River, Save the Rouge received an adverse cost award of $10,000 against the OMB, and the board claimed that I had been deceptive. The representative of the SRVS had a long history in trying to preserve this habitat, and I have to say that both John McKenzie and Natalie Helford can exonerate me in this case, and that Murray Chussett has been asked numerous times to release correspondence that will exonerate me, I'm speaking to the record obviously here, but this has rankled for some 7 years now, and I'd like to see my name cleared in the Warden 16th case, where this is simply untrue. The board was lied to, and the board misrepresented the facts. Now, even big players can get intimidated by slap suits. John Crispo, former DVUT, said the threat of these slap suits is so intimidating, and that the whole purpose of this stuff is to instill citizen chill, and it works. The good news is that thanks to the Advocacy of Environmental Defense, both the City of Toronto and the cities of Oakville have asked the province to pass slap suit protection, but we need to make sure that our situation at Big Bay Point is never repeated. My wife got shingles as a result of the stress of dealing with this issue, and it has an impact on my own personal health. But I will say this: most people, while they support tort reform, are not interested in hiring more lawyers and availing themselves of more legal processes. If the fix is to work, we have to stop publicly funded statutory public consultation processes hosted by the Government of Ontario, where there is the threat of lawsuits hanging over citizens. In the case of Big Bay Point, the environmental assessment has commenced. They're holding public meetings, and the people who swore those affidavits, who say that they won't write a letter, won't come to a public meeting, are refusing to show up at public meetings that we pay for as taxpayers. And that if any fix that needs to come through slap suits, in my personal opinion, having spoken to dozens of people who have been impacted by this, is that we have to stop these public meetings, stop these public consultations if there are slap suits outstanding against members of the public who have criticized the project. And the only way that's going to happen is if we get your help. Thank you, and thank you for indulging me speaking to the record a little bit here tonight.